Good afternoon. Yes. My name is Kate York. I'm a staff attorney with the Legal Aid Society of the Orange County Bar Association. And in Orange County, Legal Aid actually runs the Guardian Ad Litem program. I work primarily in dependency, and I also have a dependency delinquency crossover project.
And my name is Coravius Coward. I also work for the Legal Aid Society in the Guardian Ad Litem program, and my primary focus is on our dependent youth with disabilities, with developmental disabilities.
And my name is Lauren Pankush, and I'm the Developmental Disabilities Case Coordinator for the GAO program in Orange County.
And our training today is going to talk about why wait for the waiver, educational and behavioral services for crossover youth not on the APD waiver. So a little outline of our presentation. We're going to discuss some of the basics of delinquency, who are crossover kids, some educational and behavioral services, and long-term outcomes for these children. And we would like, if we could wait for the end of the presentation for questions, just so things move along pretty quickly. So some basics of delinquency. If you're anything like me, you primarily practice in dependency and don't have a lot of crossover into delinquency. So children in delinquency can be charged with delinquent acts. It can be any offense that would be a crime if you were over the age of 18, although there are a few that are limited just to minors. The general process is a child is detained generally by police. The assistant state attorney has the option of filing a delinquency petition against the child. The child can either enter a plea or go to trial. The sanctions generally include probation or possible commitment into a commitment facility. Similar to dependency, the juvenile rules of procedure are in play here, and they protect the constitutional rights of the child. Children have the right to counsel, are often indigent, and the focus is more on rehabilitation and not on punishment, unlike with adults. Unlike adults, they're not arrested but detained. There is no bond, but they can get a release order. There's no jury, so it's a bench trial with the judge. No fines, but there can be court fees which can be waived for children in foster care. And it's very fast. Every offense has a 90-day speedy trial limit. And similar to dependency, the file is confidential. So as a guardian ad litem, case manager, or just person who works in child welfare, your ability to participate in delinquency hearings can vary depending on if your circuit has unified family court or not. Unified family court is essentially if a child picks up a delinquency and already has a dependency case, or vice versa. The cases are transferred to one judge. That judge will hear both the dependency and delinquency cases until one of them resolve, and then the other one generally gets shot back to the original judge. The Ninth Judicial Circuit, which is where I practice, just began the Unified Family Court model this past January. The benefit of having Unified Family Court is that everyone is in attendance for each court hearing. They have multidisciplinary staffings in which everyone is involved. So it's a lot of sharing information. That judge knows everything about that child's background, the abuse history, the child's educational background, the services the child is getting in both cases. If you do not have Unified Family Court in your circuit, you can still participate in the delinquency case. You can attend delinquency hearings. They are open to the public. You can talk to the child's public defender. And you can even request either participant or party status as the guardian ad litem. I also wanted to talk a little bit about competency, which I think is especially relevant with kids who would qualify for APD based on either an intellectual disability or another disability. So a child is assumed competent to proceed. A child is competent to proceed if the child has a sufficient present ability to consult with counsel with a reasonable degree of rational understanding, and the child has a rational and factual understanding of the proceedings. This includes the child's capacity to appreciate the charges against them, appreciate the range and nature of the penalties that they could suffer, understand the adversarial nature of the proceedings, disclose to counsel facts pertinent to the proceeding at hand, display appropriate courtroom behavior, and to testify relevantly. If at any time of the case, it could be at the beginning of the case, it could be in the middle of trial, any party or the judge has reason to believe that the child is not competent, the judge has to stay the proceedings immediately, and there needs to be a mental health evaluation of the child. These would be at least 2 evaluations, but not more than 3. So the evaluators can be different based on the different needs of the child. If the child has a mental illness, the Department of Children and Families shall maintain and annually provide the courts with a list of mental health professionals who can perform the evaluations. If the child has an intellectual disability or autism, the court must order the Agency for Persons with Disabilities, APD, to examine the child to determine if the child meets the definition of intellectual disability or autism, and if so, whether the child is competent to proceed. There are consequences to a child being determined to be incompetent. A child, if they are accused of a felony, this doesn't apply to misdemeanors, may be placed in a secure facility or program if the court makes a finding by clear and convincing evidence that the child has a mental illness, intellectual disability, or autism, and because of these, the child is manifestly incapable of surviving with the help of willing and responsible family or friends, including alternative services, and without such treatment or training, the child is likely to suffer from neglect or refuse to care for oneself. And such neglect or refusal poses a real and present threat of substantial harm to the child's well-being. Or there is a substantial likelihood that in the near future, the child will inflict serious bodily harm on themselves or others, as evidenced by recent behavior, and all available less restrictive alternatives, including treatment or training, would be inappropriate. So it's kind of a 2-prong test. The sole purpose of the treatment or training is to restore the child's competency to proceed. Now, the court must retain jurisdiction for 2 years and then make a determination as to whether within a year of those 2 years the child's competency could be restored. So essentially, it's at the 3-year mark. If there's no chance this child's competency is going to be restored, the judge must dismiss the delinquency petition. And the judge can actually dismiss the delinquency petition at any time it's determined the child will never be competent to proceed. However, never being competent means just that. It doesn't mean the child will be competent in several years, months. If you look at State v. JLM, in that case, child was 8 years old. 2 experts opined that the child would probably not be competent until around the age of 12. The defense requested a dismissal, and the court granted the motion. However, the state prevailed on appeal because there was no evidence the child would never be competent to proceed. You cannot commit a child to a competency restoration program if the incompetency is due to immaturity or youthfulness. So there are competency restoration programs in the state of Florida. The outpatient program is the Twin Oaks Forensic Outpatient Services. Unfortunately, they don't provide mental health services. You would need to go to a different provider for that, and oftentimes the juvenile probation officer can help set up referrals for these other agencies. The inpatient is it's Apalachicola Forest Youth Camp, located in Liberty County, Florida. A 39-bed facility operated by Twin Oaks under contract with DCF. It is apparently located in the middle of nowhere, the wilderness area. That doesn't surprise me. It apparently looks like a log cabin. But lots of security measures, cameras, 14-foot high fence. It consists of 7 to 8 person cabins. They get individual bedrooms. There's an educational building, a professional building with nursing coverage, and an administrative building. And of course, once the child is restored to competence, then the delinquency proceedings would restart. So at this youth camp, some of the therapies they use, very structured daily schedule with group competency training, which is daily, individual competency tutoring, which is weekly, and individual and group counseling for the child's individual needs. They also have social skills training, special education, behavioral management, psychiatric, medical, dental services, and some recreational activities. Now I'm going to talk a little bit about direct filing. Luckily, I have no personal experience with this on my cases, but the assistant state attorney does have, in certain circumstances, the ability to direct file against youth. That means that the youth essentially is treated as an adult and tried as an adult, and their sanctions are that which an adult would normally get. There are some that are discretionary for the assistant state attorney and some that are mandatory. For the discretionary direct filing, for 14 and 15-year-olds, if the offense is basically a fairly serious felony, you have commission of, attempt to commit, conspiracy to commit, things like arson, murder, sexual battery, aggravated stalking, kidnapping, that sort of thing. The assistant state attorney has the option of direct filing. For the child who is 16 to 17 years old, it's essentially any felony they could possibly direct file. For mandatory direct files, can actually be at any age for the child. If the child stole a motor vehicle and caused serious bodily injury or death to another person. For kids who are 16 to 17 years old, if they have had 3 forcible felonies at least 45 days apart from each other, or if they possessed or discharged a firearm in the commission of certain crimes, again, the more serious felonies, murder, arson, robbery. However, there is a caveat that it shall not apply if the state attorney has good cause to believe that exceptional circumstances exist that preclude the just prosecution of the child in adult court. But again, this is all at the discretion of the assistant state attorney. So what are the possible sentences if a child is direct filed against? the adult sentence, anything that the adult would be, could be sentenced. However, there is a caveat, actually that's the next section, or impose the delinquency sanctions. They do have the option of doing either or. If a child gets an adult sanction and ends up in prison or jail, the Department of Corrections must have the child separated from the adult population. Although the statute is actually somewhat vague, it says corrections must make reasonable efforts to keep the juvenile separated. If the child is acquitted in adult court, if a child is acquitted of all charged offenses or lesser included offenses contained in the original case that is transferred to adult court, all felony cases that were transferred shall be subject to the same penalties to which cases would have been subject to before being transferred to adult court. Oops. Well, I also added a section, essentially the judge doesn't have the option of imposing delinquency sanctions if the crime is punishable by death or life imprisonment. So once a child is released from, let's say, a commitment facility or even prison or jail, how to reinitiate services for that child. I think the first thing is to get records from that facility to see if they've made, if they had therapy while they were there, what kind of progress did they make, what was their treatment plan, and also the educational records to see where they are. To staff it prior to the child's release so we can get all the service providers in place. Yeah. And just to talk a little bit about crossover kids. Again, as I said, crossover child is someone who has a delinquency case and a dependency case at the same time. Oftentimes we see our dependent kids in a group home or a foster home. They may end up picking up charges because of, let's say, a fight with another youth in the group home or a fight at school. When we see kids cross over from delinquency to dependency, generally speaking, it's that the judge or public defender in the delinquency case realizes or has some concerns that the child is either being abused, abandoned, or neglected, calls in an abuse report, or shelters the child immediately. A lot of times we see kids cross over because of violations of probation, things like curfew violations, things of that nature, not going to school. Crossover children are more likely to be arrested and arrested more often than other youth, less likely to be offered diversion programs, and more likely to be placed in commitment programs. When a child crosses over, advocacy by the guardian ad litem and other caseworkers is essential. You can be the reporter of the history of that child, the things that that child has suffered through. You can report different services that the child is already getting or may need. And you can be an emotional support for the child as well. Also, your presence in that delinquency case will show that judge that there's someone out there who cares about this child. Our next speaker, Lauren, is going to talk about educational issues for these children.
Thank you. So as Kate said, my name is Lauren, and again, I'm the Developmental Disabilities Case Coordinator for the GAO program in Orange County. So I'm going to review educational services with you. Kind of what are they? What are they going to assess? How do we obtain them? And what are the requirements of the school system to provide them? I'm also going to review how do we use the school as a tool for securing these services, both educational and beyond. So education in regards to disability. Individual with Disabilities Act, or IDEA, ensures that all children with disabilities are entitled to a free, appropriate public education in the most least restrictive environment possible. The purpose of ESE, or Exceptional Student Education, is to help the child progress in school, to meet his or her goals, and to prepare for life after school. And programs or services are available for students age 3 through 22. Schools are required to locate, to identify, and to evaluate all children with disabilities from birth through age 21. The child find mandate applies to children who attend public and private schools, highly mobile children, migrant children, homeless children, and dependent children. This includes all children expected of having a disability regardless of whether they are receiving passing grades or advancing from grade to grade. So as you can see, it's a varying degree of children who fall under this. So what are our educational options? So for children who are required to attend school, which is ages about 6 to 16, two things hold true. The Department of Education is the lead agency for juvenile justice education programs, curriculum, support services, and resources. Noting that the coordinator for juvenile justice education programs serves as the point of contact between DOA, Department of Education, and DJJ, Department of Juvenile Justice. And it also holds true that the district school board located in the county where the educational program resides is responsible for ensuring that the children have appropriate educational services. So the education program should provide instruction based on each student's individualized transition plan. It should provide instruction assessing the educational need and the education programs available in the school district to which the child will return, whatever location that would be when they gain permanency. This program must follow the child's IEP, and it must provide assessments to evaluate the child's needs. So if a youth has been adjudicated and they are entering a DJJ program, there's two things we want to do. So the first thing is we need to assess them. So a DJJ, if they're entering a DJJ prevention, residential, or day treatment program, within 10 days of entering that program, they need to be assessed. So the child is going to be assessed for two things. The academic measures that provide proficiency levels in English language arts, mathematics, and also in career interests and aptitude measures. So after we finish the assessment, we want to put it towards something, right? So we have to develop a plan. So we need to develop this plan within 3 days of the assessment. And an individual progress monitoring plan is going to be developed. This plan shall be based upon the students' entry assessments and their past educational history. So we're going to combine our entry assessments and all of their educational history to give us a better idea of where we move forward with the plan. The plan should include specific individualized academic and career objectives, remedial strategies, progress monitoring evaluation procedures, and an implementation schedule for determining progress towards meeting the goals of the academic and career objectives, including specific monitoring responsibilities. It's also important to note that an ESE student's progress monitoring plan must be consistent with the student's IEP. So exceptional student education, or as we refer to it, ESE, this program provides specialized school services for students ages birth to 21 years old, and this is per the Florida Administrative Code. So all of the things that you see listed on this slide are all listed conditions that the ESE program will provide services for and consider. I did want to note that that the one on there that says preschool diagnostic intervention services, which in Orange County we refer to as PDIS, there may be a similar program in other counties but may not go under the same name. And then just listed throughout here are all the different conditions in which ESE would look for. So needs addressed by special education. So some children are going to have needs that are related to their disability, and they're going to affect their ability to both learn and to participate in classroom activities. So the students may benefit from evaluation if you see any of these things going on. If the student is not meeting early childhood developmental milestones, that could be a cause for concern. And if you personally are not familiar with early childhood milestones, a good place to access that information is from the CDC website. If you also notice maybe that the child is having difficulty with speech or communication, that could be something to look for. If they're having difficulty with vision or hearing, if they're having trouble paying attention and following directions in school, communication with peers, walking or moving differently than peers, so their physical motion, those are all things that we would want to look for to potentially evaluate. So when we're looking at appropriate programs, we want to consider the multi-tiered system of supports, or MTSS. And this is considering the level at which we apply supports. So this model goes in 3 different tiers. Our biggest tier, being at the bottom in green, is going to contain most of the kids within a school system. These kids will be given general instruction that'll identify the areas of need academics and social and emotional skills. So this is going to be most kids. Then we're going to move to Tier 2, which is up there in the yellow. As you can see, it's a considerably smaller amount than the green. And this is going to be the supplemental intervention and supports. Additional supports are going to be given to these children on the general curriculum, and they're also going to monitor the students' progress as they go through. An example of this might be giving a child additional task explanation or pulling them to the side to go over tasks. And then we have Tier 3 up at the very top in red. And this is specifically identifying intensive, individualized supports. So this is going to be targeting specific learning or behavior goals, increased instruction time, and reduced group size instruction in area of need. So an example of this might be a completely separate ESE classroom for the entire day program, or potentially just for certain subjects. And this model is important because when we look at this, it reminds us that we want the least restrictive means. We don't want to be restricting the child more than they need to be. So next we have 504 plans. So these plans are offered by ESE Services, and these are separate from an IEP. They're also a step below the IEP, and they're for substantial impairment. They're for impairment substantiality limit. I'm sorry, it's really blurry on my screen. But basically, the section of the 504 comes from the Rehabilitation Act of 1973. And this is going to require school districts to provide free, appropriate public education, or as we refer to it, FAPE. And this is going to protect against discrimination for children with disabilities. So this plan is going to offer accommodations with presentation of the information, considering how a student will demonstrate learning, what are the classroom settings, scheduling, instruction, and assessments, and these do not change the learning expectations of the child. The plan makes modifications as changes in curriculum by assessing points, reducing complexity of general curriculum, and they are tested on the Florida Standards Alternative Assessment. So that leads us to the IEP, or the Individual Education Plan, and this is another plan under ESE. This is slightly more intensive than a 504. And an IEP is a written plan to address the student's educational needs in order to ensure that they receive a free and appropriate public education. I think appropriate is the key word here. So depending on the student's IEP, it's going to include varying things, which is under our first list on the left. It's going to potentially look at communication goals. It's going to look at social emotional behavior goals, curriculum goals. What are the healthcare needs? Does the child have nursing needs or treatment or medication that needs to be taken into account? What is the parent or student input in all of this? And then in addition to that, we also look at special considerations that are given in the IEP, which are the following list on the right, which could include behavioral that impedes the learning of the student or others, limited English proficiency, blind or hearing impaired, deaf or hard of hearing students, communication needs, and assistive technology and device needs, and ability to participate in regular PE or adaptive PE. And it's always better to get as much identified on an IEP as is present in the child in order to best help them in their educational needs. So now that we know what we need to assess for, we know what requirements to assess for, how do we actually obtain these services through the school? And what requirement does the education system have in providing these services to our kids? So evaluations and eligibility. In order to obtain services, there must be a consent for evaluation that is signed by the educational decision maker, which could be the parent, the legal guardian, or potentially the surrogate parent. The school is going to have 60 days to complete this evaluation. This is going to exclude school holidays and student absences, and the school also gets 90 days for reevaluation. Some items that they're going to assess for could be grade level testing, standardized testing, speech and language evals, FBA or functional behavioral assessments, psychological or full IQs, adaptive behavioral testing, and teacher and service provider input. So advocacy at school meetings. As all of you probably are, you serve as an advocate for someone. So if you are attending a meeting, what can you do or what should you do before you go into an IEP meeting in order to have a successful one? So there's a couple things that you can do before the meeting. One would be contacting the school staffing specialist, which is a person listed on the school staff, or the school board attorney, and this is to request a meeting or to attend one that has potentially already been scheduled, so to keep yourself informed of when that is. You're also going to want to request copies of previous testing and previous IEPs, report cards, and attendance, and you want this data in order to assess where the child's been at in the past so that you can make appropriate means for them to succeed in the future. So it's always good to have some data of their past educational experience to go off of. And then you're also going to want to try to meet with parents, caregivers, students, the student particularly, to find out what concerns that they want to address. So are there things not in any of those documents that maybe they have concerns about? Being someone who spends a lot of time around the student or being the student themselves, they may have certain concerns of something that they want to progress in or achieve that may not be outlined in the paperwork. So now that you've prepared for the meeting, what do you actually do in the IEP meeting? So during the meeting, you're going to want to look for these things listed in the IEP. You're going to want to look for data monitoring the child's academic and or behavioral progress. You're going to want to look for specific, attainable short-term goals that progressively meet an annual goal. So you're going to want to have a main goal and then baby breakdowns of mini goals to lead up to that. What is the classroom size listed on there, and is it appropriate for the child? If we're considering least restrictive means, maybe the classroom size is too small and the child would do better in a larger classroom size. You're going to look at the time spent with non-disabled peers. So, for example, maybe an autistic child who could benefit from social interactions or observing on-level kids, so being in an environment where there are kids on level. You're going to want to look at therapies that are provided in school and also if extended school year is needed. Implementation of services. So depending on the IEP, services may be initiated immediately. They may be initiated after a school break or the next year upon school changing. So the times of implementation may differ, and this is based on what's appropriate for the child. So as services are going on, you want to review the child's progress. How are they lining up with that goal, those goals that we set in the IEP? What are the teacher's notes saying about the child's progress? Progress reports, report cards, and standardized testing. And there's also things that you can do if you feel like the needs are not being met for the child. And this is requesting additional meetings with school officials, requesting mediation, and requesting an administrative due process meeting. So another service of the school that you can implement for a child is a behavior intervention plan, or a BIP. And this is going to address the range of a child's behavior and the input and training from the school employees who are going to implement it. So this plan would potentially be implemented by ESE teachers or normal staff members. Functional Behavioral Assessment, or FBA, is going to do the first part of that by assessing the behavior. So you're going to identify target behaviors, when, where, what triggers, or in what situations do these behaviors occur in, and also the student's history. So after you have that initial assessment, the second step, as I'm guessing you've already figured out, is to put a plan in place. And the plan is the behavior intervention plan. And this is going to identify the desired behavior of the child, specific intervention strategies for preventing problems, teaching appropriate behavior, and managing consequences. And then we have disciplinary measures. So what protections do we have in the school system for individuals with disabilities? 4 procedures for students with IEPs or students having suspected disabilities. These things are true. You cannot be suspended from school for more than 10 days in the same school year. You cannot be expelled if behavior is a manifestation of that disability, and they're still entitled to ESC services if they are removed from the school. And then this bottom portion here just kind of goes over the manifestation determination. You know, where is that behavior manifesting from? Where is it stemming from? And looking at different parts of that. Is the conduct caused by or had a direct and substantial relationship to the child's disability? If the conduct was the direct result of the school district's failure to implement the IEP, and then FBA and BIP must be updated if an 11th day of suspension will occur. So the next part of this presentation is going to be on the behavioral services, and I will let Cravius take it.
Good afternoon again, everyone. My name is Cravius Cowart. So far, Kate has introduced you to delinquency and our crossover kids and the different types of services that they can receive in the delinquency arena. And Lauren gave you the services that are available in education. So this next section is more geared towards in-home, group home, foster home, outside of those other 2 settings. So first we need to determine the need. And we want to ask questions like, will the additional services help the child come to school ready to learn? Will it reinforce social/emotional skills taught in the classroom? Will it prevent regression during school breaks? Will it educate parents and caregivers on how to handle the child's special needs? Recommendations for appropriate services can be made by a comprehensive behavioral health assessment. Agencies such as Kinder Consulting, which does psychological, psychiatrics, provides therapeutic interventions and things of that nature. Services like Wraparound Orange. I think they spoke earlier about the Wraparound program in this morning's general session, where you try to bring as many services into the home so the family unit can remain intact as possible. And then referral and other organizations like the Center for Autism and Related Diseases, which, like I said, will help individuals and families secure services or find other agencies that provide services for children that are autistic or have other related disabilities for those families. So what do these behavioral services look like? One of the first ones to start with, and play is play therapy. So what play therapy does is engages children in structured play activities to address treatment goals such as communicating feelings, modifying behavior, problem solving, and resolving conflict. This is something that you'll usually see in toddlers and our younger children. Obviously, when we're talking about our children that are developmentally disabled or have some type of barrier, they can be in play therapy as well. So you can have a 17-year-old who's developmentally disabled that might be in play therapy because it's developmentally appropriate for their age. It can involve siblings, parents, and caregivers. Next, you have your different types of psychotherapy, which include individual therapy, group therapy, family therapy, which involves the parents, caregivers, and children. Helps with parenting skills, may be incorporated into the parents' therapy, and also may include things like therapeutic visitation. And lastly, on the psychotherapy, we have trauma-focused cognitive behavior therapy. These are some of the issues that you'll see this approach used for. It's like sexual abuse, physical abuse. And here in Orange County, we have the Healing Tree and the Children's Advocacy Center, which kind of focus heavily on cases like that. In your county or circuit, I'm sure there's something similar, but probably just by a different name. Also, you have behavioral therapy. So applied behavioral analysis, which identifies harmful behaviors, develops treatment plans to replace harmful behaviors with useful ones, implements intervention techniques, and monitors the effectiveness of those interventions. So that therapy can be comprehensive, which means it can address a full range of behaviors or life skills. It can be early intervention, addresses behaviors for children under the age of 4, and it can be intensive, which is a full-time program of 25 to 40 hours. And the therapy should be overseen by a board-certified behavior analyst or a licensed clinical psychologist. Next, we have medication management, and as guardian ad litems, this is one of the things that we try to resort to last is placing a child on any type of psychotropic medication. But if the need arises, that's what medication management is for, which allows for prescriptions the prescriptions and dosages to be reviewed. It monitors the effects of the medication, explains the diagnosis and the treatment plan, answers questions and addresses concerns. It coordinates care between healthcare providers, and it helps the patient safely follow the treatment plan. Here in Orange County, our kids that are usually involved in medication management are seen by a psychiatrist every 30 days, which is a good short time not to have a child, on a medication without the psychiatrist coming back in to see if it's having an adverse effect on the child. Is it really working? Can the dosage be increased? Can it be reduced? Does the medication need to be changed? Can it be stopped completely? So 30 days is a good time frame to measure those outcomes. And lastly, under behavioral services, we have our specialized placements, which provide housing and address treatment needs for youth with developmental disabilities and mental health issues. Students may continue to attend schools and activities in the community, or may receive on-site instruction or hospital homebound services. And again, just like medication management, the specialized placements are, as guardian ad litems and as child welfare professionals, this is something that we seek as a last resort because we want the least restrictive means. So for developmental disabilities, the type of placements you have DCF, the family care homes, and under APD, we have APD group homes and residential rehabilitation centers. Under mental health, we have therapeutic foster homes, and they come in 2 levels, level 1 and level 2. And then you have a therapeutic group home as well as your full-out residential treatment lockdown facility. Okay. Next, moving on to long-term outcomes. So pretty much everything that we've touched on so far is really for children 18 or younger, with the exception of education, which can go to 21, and things like that. So really now we want to focus on long-term outcomes, and we're talking about our older youth when they're turning 18, when they're ready to be adults and move into adulthood. So first we have the supported decision-making model. And this is an alternative to guardianship. And what it does is it allows the individual with a disability to work with a team to make his or her own decisions about his or her own life. And under this model, the individual designates people to be part of a support network to help with this decision making. So these people can include family, friends, peers, or community support such as case management, guardian ad litems, therapists, anybody within the community that knows the child, that's worked with the child, former teachers, mentors, anything like that. Anybody that the child would want to be involved in that decision making can be involved. And really, when we're talking about our kids with disabilities, this is probably the first thing you want to look at, and ask yourself, okay, is this a youth? Even though this youth has a disability, he's not quite APD eligible, but then, he's still low functioning. So is this a youth that we can look at the supported decision-making model? Can he make some decisions with the appropriate supports? And so that's the first thing we want to take a look at. Next, we also have extended foster care. Okay, and this is for our young adults that turn 18 while in foster care. So long as they're living in licensed care at the age of 18, they're eligible to remain in licensed care if they're completing a secondary education, they're enrolled in an institution that provides post-secondary or vocational education, they participate in a program designed to promote or eliminate barriers to employment. So like the Goodwill to Work program, I think, is one of those programs, and there are other like job training programs like that. They're employed for at least 80 hours per month, or they are unable to participate in any of the above full-time due to a physical, intellectual, emotional, or psychiatric condition that limits participation. So while the last requirement pretty much is a catch-all for the kids that we're talking about, again, we want to look at that supported decision-making model and ask, can this young man, or young lady, go and work at, a place like Chick-fil-A and do stuff like that? Can they work there? Because they can probably, fulfill the EFC requirement by having a job. And what it does, it helps them with responsibility and things like that. Even though we can, sometimes get them into EFC under the last requirement. They must also be in a supervised living environment that is approved by the Department of Children and Families. This can be them remaining in their foster home post-18, remaining in their group home post-18. This can be, them living with a relative or a non-relative. And I know CBC and my friend Jerry might kill me for this, but this may even could be an apartment-like setting. Now that would be a more extreme situation if all other options have been explored and there are just absolutely no other available placements. That'll definitely be something of a last resort that they will look at, but it's something to keep in mind in the back of your heads as GALs to possibly push for if options are far and few in between. The young adult can remain in extended foster care until the age of 21 or 22 if they have a disability. And next, one of the other long-term outcomes can be a guardianship. And again, this is This is something that we don't like to go towards, but again, we have some youth that can't make a lot of decisions on their own, and they need guardians to be put in place. So, a guardianship is a person or other entity that is given permission by a court to exercise certain powers over an incapacitated person. The ward is deemed to be unable to make or communicate sound decisions, as well as their property, about him or herself, as well as their property, or has become susceptible to fraud or undue influence. Legally, they are responsible for the care and management of the person or property of the incapacitated person. What rights can be removed with a guardianship? The right to determine residence, consent to medical treatment, contract or file lawsuits, possess a driver's license, manage, buy, sell property, own a firearm, make end-of-life decisions, and to vote. So those are just some of the things that can be taken away from an individual under a guardianship. And the two types of guardianship that we have are plenary, which take away all the rights, and limited, which the court allows the person to retain some rights. So if you have youth where you feel that they need a guardianship, I would implore you to try to look at a limited guardianship first and as much as possible before going the plenary route. Okay, and next we have a guardian advocate, which is a type of limited guardianship reserved for an adult with a developmental disability. Two types of classifications of a guardian advocate of the person, which means that the ward has no property. The individual may still receive Social Security benefits. The rights that are exercised by the guardian advocate are limited to the person, and this can be handled in probate court without an attorney. Guardian advocate of the property. The proposed ward has property or certain sources of income, and Florida statute requires that an attorney handle this if one is needed. So, why did the legislature create the guardian advocate process in the state of Florida if we already had a guardianship, limited, and plenary? They intended to simplify the process for families seeking guardianship over individuals with developmental disabilities, and to minimize the cost by eliminating the examining committee, because most families have the documentation already to support the developmental disability, which is all a guardian advocate requires, is that the person be diagnosed with a developmental disability. And it also allows the families to pursue a guardian advocate themselves without attorney representation. This is especially when the ward only receives Social Security benefits. So, who can be a guardian or a guardian advocate? Any resident in Florida who is 18 years or older. Any non-resident who is related to the ward. A nonprofit corporate guardian or a corporate guardian. A professional guardian and a public guardian. Who cannot be a guardian or a guardian advocate? Judge, unless they're related to the ward, or they've maintained a close relationship with the ward or the ward's family, and they must serve without compensation. A person convicted of a felony, a person who has been judicially determined to have committed abuse, abandonment, or neglect against a child as defined in Chapter 39 and Chapter 984, or who has been found guilty of any offense under 435.04. We're going to come back to that in just a second. A person who provides substantial services to the proposed ward in a professional or business capacity. So, for instance, group home staff, waiver support coordinators with APD, those individuals cannot be guardian advocates of a person. And a provider of healthcare services cannot be a guardian advocate. So, one of the last thing I want to look at when we talk about long-term outcomes is the recently, I guess it's not as recent now, but the Regis Little Act. Basically, it requires that at the 17-year-old judicial review for the youth, the dependency court must make a determination that there is a good faith basis to believe that the child qualifies for appointment of a guardian advocate, limited or plenary guardianship. and that no less restrictive decision-making assistance will meet the child's needs. The department must complete a psychosocial evaluation and educational report if one has not been completed within the past 2 years, and must identify one or more individuals who are willing to serve as the guardian advocate. And just a side note, if you work with youth or a number of youth that need guardians or guardian advocates, you'll find that the most difficult part in this process is finding people to serve as guardians. Because if they had relatives to serve as guardians, then chances are they probably wouldn't be aging out of foster care. They probably would be with those relatives or something like that. Okay. The child's parents, if the rights have not been terminated, may serve as guardian advocate if the court finds that such an appointment is in the child's best interest. So just to go back briefly to the previous slide where it talks about a person who has been judicially determined to have committed abuse, abandonment, or neglect. So obviously we get a lot of our cases that come in with our youth that are disabled are situations where they just simply can no longer be maintained in the home because of the size of the child, younger children in the home, they have aggressive behaviors, things of that nature. But oftentimes, if these parents end up having to call DCF, they can be found to, the child can be adjudicated dependent, and the parents can be found to have committed, been judicially determined to commit abuse, abandonment, or neglect. And so what the Regis Little Act does is, I think it allows for the court to take into consideration those situations and still, although that child cannot be maintained in the home, once that child turns 18, find that it's in the child's best interest for the parent to serve as that child's guardian advocate. Okay, this is something that you probably, as a guardian ad litem, you probably wouldn't ask the court to do in cases of physical abuse or medical neglect, but these are really, the way I envision it, the cases that we consider to be special conditions cases. Okay. And lastly, the proceedings for the appointment of guardian advocate may be initiated within 180 days after the child's 17th birthday. And this is very important because if you can start the process at 17 year and 6 months, what you can do is hopefully have this in place by the time the child turns 18, so there's no lapse in the child having a legal guardian and a guardian advocate. Okay, and that brings us to the end of our presentation. I know there was a lot of information in a lot of different arenas, so if anyone has questions about anything, feel free to ask. And all these sections could truly be broken down into their own separate trainings and presentations, but we kind of wanted to streamline it and let everybody know what can you do for this specific group of kids who are going through these specific issues. So if anybody has questions, please feel free to ask now. And please come to the microphone. It's on the front table right here.
This is for Kate's part. You talked about Twin Oaks. Why would you send a child there for competency if there's no mental health services offered? What would be the basis for doing that?
Is this working?
Just turn it on. Yeah, turn it on.
Hello? Oh, perfect. There is an inpatient part of Twin Oaks, and then there's an outpatient. The outpatient section doesn't deal with mental health issues, but you can get other service providers to handle that aspect of it. When you're dealing with competency restoration, it is really specific to competency. I mean, it's similar to basically trying to get them to understand the particulars of delinquency. So they don't really address really some of the underlying issues. Now, in the inpatient portion, they do handle some of that mental health, anger management, and, through individual counseling as an added component to also dealing with the pure competency issues, if that makes sense.
So the outpatient just deals with, I guess I'm so confused as to what the outpatient services are.
So it's
What would they
essentially the counseling to deal just with getting that child to understand the delinquency process.
Okay. Now I got it.
Thank you.
Any more questions? All right.
Yeah, this one's for Lauren, specifically about the IEP process. Is there something short of exhausting the administrative process to enforce some of the provisions or make sure that the goals are obtained in an IEP?
I can answer some of that because I've been to quite a few IEP meetings. Sometimes your presence there is enough to make sure that the school is following the requirements through the IDEA. Oftentimes, coming in as an attorney kind of makes them sit up and pay more attention and be more careful regarding what they're doing, So I find that I don't often need to resort to any kind of appeals. And the schools that I've dealt with all really care about the child and they want the child to succeed. So we've come up with some creative solutions to some of the issues that the child is presenting, and it's a very collaborative effort. I don't know if that answered your question at all, but
No, it did. Thank you.
So there is another process that's the complaint process. So the IEP is funded through federal dollars to the state and the state to the local school board. If the state of Florida as a whole violates the Individual Disabilities Education Act, then the whole state loses money. So the State Department of Education has an obligation to make sure every school board is complying with the IDEA. So you can file a complaint with the State Department, and I forget the official webpage, but it's been a while since I've done it, that you can file a complaint, and then the state will investigate your local school board and their compliance with the IDEA. I often refer to it as the poor man's due process. Rather than that expensive administrative process, file a complaint that way, and then the Florida Department of Education becomes an ally on behalf of the kid to make sure the school board is complying with the IDEA.
I'm sorry, we're becoming undressed up here. So.
Okay, assuming that I don't know anything about APD applications, if APD is evaluating kids for competency in their delinquency cases, can that evaluation be used in their APD application? Or are they taking that into consideration? Like if they aren't competent to proceed with their delinquency charges, is that going to have any factor on them being APD eligible?
Well, I mean, I think, so with APD, you need one of those qualifying diagnoses, which are, I'm gonna try to roll them off, autism, Down syndrome, intellectual disability, Prader-Willi, spina bifida, Phelan-McDermott, and I'm forgetting one. Cerebral palsy, there it is. So I don't see why you couldn't use it as a part of the application. chances are you probably would want to have other evaluations as well. I'm really not that familiar with the competency evaluations, so I don't know how involved they are.
I can answer the question. And yes, APD would consider that information. And to echo what he said, it may be that additional information is needed. We would definitely want to see that information.
APD would want to consider the competency evaluation. And you're correct that we also might need to see additional information as well.
All right. If there are no more questions, we will end this presentation. Thank you all for coming, and have a great weekend. And hopefully you got something that you can take back to your everyday practice. Thank you.